CE Laws, Ethics and Contracts, Chapter 4, Implementation of Rules and Regulations of the National Building Code. Brief introduction. In its widest and most comprehensive sense, the term law means any rule of action or any system of uniformity. Characteristic of law. It is a rule of conduct. It is obligatory. It is promulgated by legitimate authority. It is of common observance and benefit. Ignorance of law excuses no one from compliance therewith. Law of obligations and contracts is the body of rules which deals with the nature and sources of obligations and rights and duties arising from agreements and the particular contracts. It is found in RA 386, otherwise known as the Civil Code of the Philippines. Article 1156. An obligation is a juridical necessity to give, to do, or not to do. Article 1305. A contract is a meeting of minds between two persons whereby one binds himself with respect to the other, to give something or to render some services. Civil Engineering Code of Ethics. It shall be considered unprofessional and inconsistent with honorable and dignified bearing for any registered civil engineer to act for his clients in professional matters otherwise than as a faithful agent or trustee, or to accept any remuneration other than from his stated charges for services rendered his clients, to attempt to injure falsely or maliciously, directly or indirectly, the professional reputation, prospects, or business of another engineer, to attempt to supplant another engineer after definite steps have been taken towards his employment, to participate in competitive bidding on a price basis to secure a professional engagement, to compete with another engineer for employment on the basis of professional charges by reducing his usual charges, and this matter attempting to underbid after being informed of the charges named by another, to review the work of another engineer for the same client, except with knowledge or consent of such engineer, or unless the connection of such engineer with the work has been terminated, to advertise in self-laudatory language or in any other manner derogatory to the dignity of the profession, to use the advantages of the salaried position to compete unfairly with engineers in private practice, to act in any manner or engage in any practice which will tend to bring discredit on the honor or dignity of the engineering profession. Lesson 1. RA 544. An act to regulate the practice of civil engineering in the Philippines. RA 544, Civil Engineering Law. Article 1, Title of the Act and Definition of Terms. Article 2, Board of Civil Engineering. Article 3, Examination, Registration, and Certification. Article 4, Miscellaneous Provisions. Article 5, Enforcement of Act and Penal Provisions. Section 1, Title of Act. This Act shall be known as the Civil Engineering Law of 2011. Section 2, Definition of Terms. As used in this Act, the following terms shall be defined as follows. Civil engineering is the science or profession in which knowledge of the mathematical and physical sciences gained by study and practice is applied with judgment to utilize natural and man-made sources and forces in the planning, design, management, construction, and maintenance of buildings, structures, facilities, and utilities in their totality, for the progressive well-being and use of mankind, enhancing the environment, community living, industry, and transportation, taking into consideration such as aspects as functionality, efficiency, economy, safety, and environmental quality. Civil engineer as used in this act shall mean a person duly registered with the Board of Civil Engineering in the manner as hereinafter provided. General practice of civil engineering within the meaning and intent of this act shall embrace services such as, but not limited to, consultation, planning, design, preparation, signing, sealing of plans, specifications, estimates, erection, installation, demolition, and supervision of construction or demolition of civil engineering structures and facilities, include their components, sites, and environs such as, but not limited to, streets, bridges, highways, and railroads, airports and hangars, port works, canals, river and shore improvements, lighthouses and dry docks, buildings, towers, signboards, billboards, chimneys, silos, containment structures, and solid waste disposal sites. Fixed structure for irrigation, flood protection, drainage, water supply, and sewage works. And tunnels. The enumeration of any work in this section shall not be construed as excluding any other work requiring civil engineering knowledge and application. Scope of practice of civil engineering encompasses the provision of professional services in connection with services of civil engineering structures and facilities, and may include, but are not limited to, technical, economic, and financial feasibility studies, project promotional services, planning and designing, pre-design services such as, but not limited to, consultation, consultancy, giving written advice and directions, evaluations, surveys, investigations, quantity surveys, appraisals and adjustments, environmental impact assessment and studies, schematic design and design development, preparation, signing, sealing of plans, specification, calculation, bill of materials, cost estimates, tender documents, invitation for bid or proposals, instructions to bidders or offerors, general conditions, special conditions, and contract documents. Construction and project management. Giving general management, administration, supervision, coordination, and responsible direction of the planning, designing, construction, reconstruction, erection, alteration, conversion, enlargement or demolition, renovation of civil engineering structures and facilities, including all their components, sites, and environs intended for private or public use. Planning, layouting, and utilization of spaces within the surrounding such civil engineering structures and facilities, include their sites, interiors, spaces, utilities, systems, equipment, and fixtures. Programming, administration, construction, arbitration, conservation, and restoration. All works which relate to the scientific and orderly coordination of all works and branches of the work, systems and processes necessary for the production of complete civil engineering structures and facilities, whether for public or private use, in order to enhance and safeguard life, health, and property, and the promotion and enrichment of the quality of life. All other works, projects, and activities which require the professional competence of a civil engineer include teaching of professional civil engineering subjects and civil engineering computer-aided design and computer-aided mapping. The term board as used in this act shall mean the Board of Civil Engineering. The term commission as used in this act shall mean the Professional Regulation Commission of the Philippines. The term Accredited Professional Organization of Civil Engineers as used in this act shall mean the Philippine Institute of Civil Engineering, which is the official national organization of all registered civil engineers in the Philippines as accredited by the Professional Regulation Commission. The term specialist as used in this act shall mean a registered civil engineer who is certified by the PICE to have demonstrated his advanced knowledge, experience, education, and training in a recognized specialization of civil engineering, and who is the recipient of a certificate of specialization set forth in Section 24 of this Act. The term Specialty Organization of Civil Engineering as used in this Act shall mean the organization of PICE certified specialists in the specialization of civil engineering. The SOCE shall be recognized as the PICE and shall be given a status as an affiliate organization of the PICE. Civil Engineer of Record is the civil engineer registered under this Act and qualified under the implementing rules and regulation hereof, who is the signatory and sealer to the plans and building permits, specifications, calculations, and other that form part of the contract documents for a project or component of a project, and who is therefore professionally responsible and liable for the design for that project or component of that project. Civil engineer in charge of construction is the civil engineer registered under this Act and qualified under the implementing rules and regulations hereof, who is the signatory and sealer to the building permit of a project or component of a project, and who is therefore professionally responsible and liable for the construction, management, and supervision of the project or component of that project. Civil engineer prime professional is the civil engineer registered under this Act and qualified under the implementing rules and regulations hereof, who is responsible for the overall integration, coordination, and successful conduct of all the processes, who is engaged in the project from inception and completion. Continuing professional development refers to a sustaining and progressive learning process that maintains, enhances, or increases the knowledge and continuing ability of civil engineers.
Article 2. Board of Examiners for Civil Engineers. Section 3. Composition of Board. Within 30 days after the approval of this Act, there shall be created a Board of Examiners for Civil Engineers, hereinafter referred to as the Board, to be composed of a chairman and 2 members who shall be appointed by the Secretary of Public Works and Communication. The members of the Board shall hold office for a term of 3 years after appointment or until their successors shall have been appointed and shall have duly qualified. The first members of the Board appointed under this Act shall hold office for the following terms: 1 member for 1 year, 1 member for 2 years, and 1 member for 3 years. Each member of the Board shall qualify the proper oath of the office before entering upon the performance of his duties. Any member of the Board may be removed by the Secretary of Public Works and Communications for neglect of duty, incompetency, malpractice, unprofessional, unethical, immoral, or dishonorable conduct, after having given opportunity to defend himself in a proper administrative investigation, provided that during the process of investigation, the Secretary of Public Works and Communication shall have the power to suspend such member under investigation and shall appoint a temporary member in his place. Vacancies in the Board shall be filled for the unexpired term only. Section 4. Powers and duties of the Board. The Board of Examiners for Civil Engineers is vested with authority conformable with the provision of this Act to administer oaths, issue, suspend, and revoke certificates of registration for the practice of civil engineering, issue certificates of recognition to civil engineers already registered under this Act for advanced studies, research, and/or highly specialized training in any branch of civil engineering, subject to the approval of the Secretary of Public Works and Communication, to investigate such violation of this Act and regulation thereunder as may come to the knowledge of the Board, and for this purpose issues subpoena and subpoena judice tecum to secure appearance of witnesses in connection with the charges presented to the Board. to inspect at least once a year educational institutions offering courses in civil engineering works, projects, or corporations. Established in the Philippines and for safeguarding of life, health, and property to discharge such other powers and duties as may affect ethical and technological standards of the civil engineering profession in the Philippines. For the purpose of these acts, the Director of Public Works and or his authorized representative in the provinces and chartered cities shall be ex folio agents of the board, and such as it shall be their duty to help in the enforcement of the provision of this act. Section 5. Qualifications of board members. Each member of the board shall at the time of his appointment be a citizen and resident of Philippines, be at least 30 years of age and of good moral character, be a graduate of civil engineering and from a recognized and legally constituted school, institute, college, or university, be a registered civil engineer duly qualified to practice civil engineering in the Philippines, have practiced civil engineering with a certificate as such for a period not less than 10 years prior to his appointment, not be a member of the faculty of any school, institute, college, or university where the civil engineering course is taught, nor have a pecuniary interest in such institutions. No former members of the faculty of any school, institute, or university where civil engineering is taught can become a member of the board unless he has stopped teaching for at least consecutive years. Section 6. Fees and compensation of board. The Board of Examinees for Civil Engineers shall charge for each application of examination the sum of 40 pesos payable to the collecting and disbursing officer of the Bureau of Civil Service upon filing of said application for examination, and for each certificate of registration 20 pesos. Each member of the board shall receive a compensation of 5 pesos for each applicant examined. A civil engineer in the service of the government of Republic of the Philippines appointed as member of the board shall receive a compensation as herein provided, in addition to his salary in the government. All authorized expenses of board, including the compensation provided for herein, shall be paid by collecting and disbursing officer of the Bureau of Civil Service out of such appreciation as may be made for the purpose. Section 7. Annual Report. The board shall, at the end of each fiscal year, submit to the Secretary of Public Works and Communications a detailed report of its activities and proceeding during the period covered by the fiscal year ended.
Article 3. Examination, Registration, and Certification. Section 10. Examination Requirement. All applicants for registration for the practice of civil engineering shall be required to pass a technical examination as hereinafter provided. Section 11. Holding of examination. Examination of candidates for the practice of civil engineering in the Philippines shall be conducted at such places on such dates determined, fixed, and announced by the Commission in accordance with the laws, rules, and regulations governing the conduct of licensure examinations for all existing professional regulatory boards under the Commission. Section 12. Subjects of examination. All applicants for registration for the practice of civil engineering shall be examined, in the discretion of the board, on the following subjects. First, general civil engineering. Second, construction management and engineering. Next, transportation engineering, structural engineering, geotechnical engineering, and lastly, water resources and hydraulics engineering. Fundamental principles. Civil engineer uphold and advance the integrity, honor, and dignity if the civil engineering profession by A. Using their knowledge and skill for the enhancement of human welfare and the environment. B. Being honest and impartial and serving with fidelity the public, their employers or employees and clients. C. Striving to increase the competence and prestige of the civil engineering profession. And D. Supporting the professional and technical societies of their disciplines. Civil engineers practice under the 7 fundamental canons of ethics. Canon 1. Civil engineers shall hold paramount the safety, health, and welfare of the public and shall strive to comply with the principles of sustainable development in the performance of their duties. Under Canon 1, we have A. Civil engineers shall recognize that the lives, safety, health, and welfare of the general public are dependent upon engineering judgments, decisions, and practices incorporated into structures, machines, products, processes, and devices. B. Civil engineers shall approve or seal only those design documents reviewed and prepared by them, which are determined to be safe for the public health and welfare in the conformity with accepted engineering standards. C. Civil engineers whose professional judgment is overruled under circumstances where the safety, health, and welfare of the public are endangered, or the principles of sustainable development ignored, shall inform their clients or employers of the possible consequences. D. Civil engineers who have knowledge or reason to believe that another person or firm may be in violation of any of the provisions of Canon 1 shall present such information to the proper authority in writing and shall cooperate with the proper authority in furnishing such further information or assistance as may be required. E. Civil engineers should seek opportunities to be of constructive service in civic affairs and work for the advancement of the safety, health, and well-being of their communities and the protection of the environment through the practice of sustainable development. F. Civil engineers should be committed to improving the environment by adherence to the principles of sustainable development so as to enhance the quality of life in the general public. Canon 2. Civil engineers shall perform services only in areas of their competence. Under Canon 2, we have A. Civil engineers shall undertake to perform engineering assignments only when qualified by education or experience in the technical field of engineering involved. B. Civil engineers may accept an assignment requiring education or experience outside of their own fields of competence, provided their services are restricted to those phases of the project in which they are qualified. All other phases of such project shall be performed by qualified associates, consultants, or employees. C. Civil engineers shall not affix their signatures or seals to any engineering plan or document dealing with subject matter in which they lack competence by virtue of education or experience, or to any such plan or document not reviewed or prepared under the supervisory control. D. Civil engineers shall not use the specialty engineering title, such as structural engineer, transportation engineer, water engineer, geotechnical engineer, constructor engineer, etc., without the PIE specialist accreditation. Canon 3. Civil engineers shall issue public statements only in an objective and truthful manner. Under Canon 3, we have A. Civil engineers should endeavor to extend the public knowledge of engineering and sustainable development and shall not participate in the dissemination of untrue, unfair, or exaggerated statements regarding engineering. B. Civil engineers shall be objective and truthful in professional reports, statements, or testimony. They shall include all relevant and pertinent information in such reports, statements, or testimony. C. Civil engineers, when serving as expert witnesses, shall express an engineering opinion only when it is founded upon adequate knowledge of the facts, upon a background of technical competence, and upon honest conviction. D. Civil engineers shall issue no statements, criticisms, or arguments on engineering matters which are inspired or paid by for interest parties, unless they indicate on whose behalf the statements are made. E. Civil engineers shall be dignified and modest in explaining their work and merit, and will avoid any act tending to promote their own interest at the expense of the integrity, honor, and dignity of the profession. Canon 4. Engineers shall act in professional matters for each employer or client as faithful agents or trustees, and shall avoid conflicts of interest. Under Canon 4, we have A. Civil engineers shall avoid all known or potential conflicts of interest with their employers or clients, and shall promptly inform their employers or clients of any business association, interest, or circumstances which could influence their judgment or the quality of their services. B. Civil engineers shall not accept compensation for more than one party for services on the same project, or for services pertaining to the same project, unless the circumstances are fully disclosed to and agreed to by all interested parties. C. Civil engineers shall not solicit or accept gratuities, directly or indirectly, from contractors, their agents, or other parties dealing with their clients or employers in connection with work for which they are responsible. D. Civil engineers in public service as members, advisors, or employees of a governmental body or department shall not participate in considerations or actions with respect to services solicited or provided by them or their organization in private or public engineering practice. E. Civil engineers shall advise their employers or clients when, as a result of their studies, they believe a project will not be successful. F. Civil engineers shall not use confidential information coming to them in the course of their assignments as means of making personal profit if such action is adverse to the interest of the clients, employers, or the public. G. Civil engineers shall not accept professional employment outside of their regular work or interest without the knowledge of their employers. Canon 5. Civil engineers shall build their professional reputation on the merit of their services and shall not compete unfairly with others. Under Canon 5, we have civil engineers shall not give, solicit, or receive either directly or indirectly any political contribution, gratuity, or unlawful consideration in order to secure work, exclusive of securing salaried positions through employment agencies. B. Civil engineers should negotiate contracts for professional services fairly and on the basis of demonstrated competence and qualifications for the type of professional service required. C. Civil engineers may request, propose, or accept professional commissions on a contingent basis only under circumstances in which their professional judgments would not be compromised. D. Civil engineers shall not falsify or permit misrepresentation of their academic or professional qualifications or experience. E. Civil engineers shall give proper credit for engineering work to those whom credit is due, and shall recognize the property interest of others. Whenever possible, they shall name the person or persons who may be responsible for designs, inventions, writings, or other accomplishments. F. Civil engineers may advertise professional services in a way that does not contain misleading language or is in another manner derogatory to the dignity of profession. G. Civil engineers shall not maliciously or falsely, directly or indirectly, injure the professional reputation, prospects, practice or employment of another engineer or indiscriminately criticize another's work. G. Civil engineers shall not use equipment, supplies, laboratory, or office facilities of their employers to carry on outside private practice without the consent of their employers. Canon 6. Civil engineers shall act in such manner as to uphold and enhance the honor, integrity, and dignity of the civil engineering profession. Under Canon 6, we have A. Civil engineers shall not knowingly act in a manner which will be derogatory to the honor, integrity, or dignity of the civil engineering profession, or knowingly engage in business or professional practices of a fraudulent, dishonest, or unethical nature. Canon 7. Engineers shall continue their professional development throughout their careers and shall provide opportunities for the professional development of those engineers under their supervisions. Under Canon 7, we have A. Civil engineers should keep current in their specialty fields by engaging in professional practice, participating in continuing education courses, reading in technical literature, and attending professional meetings and seminars. B. Civil engineers should encourage their engineering employees to become registered at the earliest possible date. C. Civil engineers should encourage engineering employees to attend and present papers at professional and technical society meetings. And lastly, civil engineers shall uphold the principle of mutually satisfying relationships between employers and employees with respect to terms of employment, including professional grade descriptions, salary ranges, and fringe benefits.
Article 4 Miscellaneous Provisions. Section 27 Preparation of plans and supervisions of construction by registered civil engineer. It shall be unlawful for any person to order or otherwise cause the construction, reconstruction, or alteration of any building or structure intended for public gathering or assemblies such as theaters, cinematographs, stadia, churches, or structures of like nature, and any other engineering structures mentioned in Section 2 of this Act, unless the designs, plans, and specifications of same have been prepared under the responsible charge of, and signed and sealed by a registered civil engineer, and unless the construction, reconstruction, and or alteration thereof are executed under the responsible charge and direct supervision of a civil engineer. Plans and designs of structures must be approved as provided by law or ordinance of a city or province or municipality where the said structure is to be constructed. Section 28. Individual and personal qualifications. The practice of civil engineering is a professional service, admission to which must be determined upon individual personal qualifications. Section 29. Partnership and corporations engaged in civil engineering and multidisciplinary consultancy. Section 30. Practice of profession by foreign nationals. Section 31. Roster of civil engineers. A roster showing the names and places of business of all registered civil engineers shall be prepared by the Commissioner of PRC periodically but at least once a year. Copies of this roster shall be placed on file with the PICE and furnished to such government entities or agencies and municipal, city, and provincial authorities as may be deemed necessary and to the public upon request. Article 5. Enforcement of Act and Penal Provisions. Section 32. Enforcement of the Act by officers of the law. It shall be the duty of all duly constituted law officers of the national, provincial, city, and municipal governments or any political subdivisions thereof to enforce the provisions of this Act and prosecute any person violating the same. Section 33. Registration required. No person, sole proprietorship, partnership, or corporation shall practice or offer to practice civil engineering or engage or offer to engage in providing civil engineering consultancy services in the Philippines without having obtained the proper certificate of registration from the board. Section 34. Requirement for a written service agreement, appointment, or employment contract. This means that any person or entity, whether private or public, Filipino or foreign, who shall entice, compel, coerce, require, or otherwise cause a duly registered civil engineer to perform or undertake any civil engineering work or professional service without first executing a written service agreement, appointment, or employment contract shall be deemed guilty of violation of this Act. Section 35. Positions in government requiring the services of a civil engineer. Within 6 months from the effectivity of this Act, all existing and proposed positions in the local and national government offices, whether appointed, career, permanent, temporary, or contractual, and primarily require the services of civil engineers, whether or not using that designation, shall be filled only by registered civil engineers who are members in good standing of the PICE. Next is the Section 36, the penal provisions. Any person who shall practice or offer to practice civil engineering in the Philippines without being registered in accordance with the provisions of this Act, or any person presenting or attempting to use as his or her own the certification of registration or professional identification card of a registered civil engineer, or any person who shall give any false or forged evidence of any kind to the board, or any person who shall impersonate any registered civil engineer of different name, or any person who shall attempt to use or revoked or suspended certificate of registration or professional identification card, or any person who shall use in connection with his name or otherwise assume, use, or advertise any title or description tending to convey the impression that he or she is a civil engineer without holding a valid certificate of registration, or any head of a government agency or officer of a private firm or institution fails to secure a special temporary permit from the board, subject to approval of the Commission prior to engaging the services of a foreign national to practice civil engineering under the employ or engagement by the agency, firm, or institution, unless such foreign national has already been issued a special temporary permit, or foreign nationals who engage in the practice of civil engineering in the Philippines without the benefit of a special temporary permit, or any person, partnership, or officers of corporation who shall violate Section 31 or any of the provisions of this Act and its implementing rules and regulations shall be guilty of a misdemeanor and shall, upon conviction, be sentenced to a fine of not less than 100,000 pesos, nor more than 1 million pesos, or to suffer imprisonment for a period of not less than 6 months, nor more than 3 years, or both at the discretion of the court. Foreign nationals who engage in the practice of civil engineering in the Philippines without the benefit of a special temporary permit shall also be subject to deportation. Section 37. Repeal. All laws, parts of laws, orders, ordinance, or regulations in conflict with the provisions of this Act are hereby repealed. No laws of other allied provisions shall limit the scope of the practice of civil engineering, nor shall exclude the civil engineer from practicing his or her professions as defined in this Act, provided that he or she does not designate himself or herself as such as other professional. Nothing in this Act would likewise limit the other professionals from practicing their own respective professions, provided that such professional does not designate himself or herself as a civil engineer. Section 38. Separability Clause. If any part or section of this Act shall be declared unconstitutional, such declarations shall not invalidate the other provisions hereof. Section 39. Effectivity. This Act shall take effect upon its approval. Civil engineering practice defined. services in the form of consultation, design, preparation of plans, specifications, estimates, erection, installation, and supervision of construction of streets, bridges, highways, railroads, airports, and hangars, port works, canals, river and shore improvements, lighthouses and dry docks, buildings, fixed structures for irrigation, flood protection, drainage, water supply and sewerage works, demolition of permanent structures and tunnels. Types of infrastructures under the domain of civil engineering pursuant to RA 544 as amended include streets, bridges, highways and railroads, airports and hangars, port works, canals, river and shore improvements, lighthouses and dry docks, buildings, fixed structures for irrigation, flood protection, drainage, water supply and sewerage works, and tunnels.
Okay, now let's proceed to Lesson 2, Republic Act 9184, the Government Procurement Reform Act, practicing of civil engineering rules and regulations in government projects. So, the Republic Act 9184 has 15 articles, but let's proceed for the Article 1, General Provisions. Okay, so for the Section 1 of Article 1, it's a short title that this act shall be known as the Government Procurement Reform Act. In the Section 2, the Declaration Policy, it is declared policy of the state to promote the ideals of good governance in all its branches, departments, agencies, subdivisions, and instrumentalities, including the government-owned and/or controlled corporations and local government units. Okay, for this Section 3, Governing Principles on Government Procurement. All procurement of the national government, its departments, bureaus, offices and agencies, including state universities and colleges, government-owned and/or controlled corporations, government financial institutions, and local government units, shall, in all cases, be governed by these principles. These principles are the transparency in the procurement process and in the implementation of procurement contracts. One of these principles also is the competitiveness by extending equal opportunity to enable private contracting parties who are eligible, qualified to participate in public bidding. Next is the streamlined procurement process that will uniformly apply to all government procurement. The procurement process shall be simple and made adaptable to advances in modern technology in order to ensure an effective and efficient method. Also, the system of accountability where both the public officials directly or indirectly involved in the procurement process as well as in the implementation of procurement contracts, and the private parties that deal with government are, when warranted by circumstances, investigated and held liable for their actions relative thereto. Next is public monitoring of the procurement process and the implementation of awarded contracts with the end in view of guaranteeing that these contracts are awarded pursuant to the provisions of this Act and its implementing rules and regulations, and that all these contracts are performed strictly according to specifications. Next, Section 4, the scope and application. This Act shall apply to the procurement of infrastructure projects, goods and consulting services, regardless of source of funds, whether local or foreign, by all branches and instrumentalities of government, its departments, offices, agencies, including government-owned and/or controlled corporations and local government units, subject to the provisions of Commonwealth Act No. 138. Any treaty or international or executive agreement affecting the subject matter of this Act to which the Philippine government is signatory shall be observed. Okay, for the Section 5, here's the definition of terms. It's for purposes of this Act that the following terms or words and phrases shall mean or be understood as follows. Approved budget for the contract or ABC. It refers to the budget for the contract duly approved by the head of the procuring entity as provided for in General Appropriations Act and or continuing appropriations in the case of national government agencies. The corporate budget for the contract approved by the governing boards pursuant to EO number 518 series of 1979 in the case of government-owned and or controlled corporations, government, financial institutions, and state universities and colleges, and the budget for the contract approved by their respective sanggunian in the case of local government units. Next is the BAC. BAC, it refers to the Bids and Awards Committee established in accordance with Article 5 of this Act. Next is the bidding documents. It refers to documents issued by the procuring entity as the basis for bids, furnishing all information necessary for a prospective bidder to prepare a bid for the goods, infrastructure projects, and consulting services to be provided. Next is bid. Bid, it refers to a signed offer or a proposal submitted by a supplier, manufacturer, distributor, contractor, or consultant in response to the bidding documents. Next, what's competitive bidding? Competitive bidding, it refers to a method of procurement which is open to participation by any interested party and which consists of the following processes: advertisement, pre-bid conference, eligibility screening of prospective bidders, receipt and opening of bids, evaluation of bids, post-qualification and award of contract, and specific requirements and mechanics of which shall be defined in the IRR to be promulgated under this Act. Next is, it refers to the services for infrastructure projects and other types of projects or activities of the government requiring adequate, it is consulting services. Okay, so consulting services, again, it's services of infrastructure projects and other types of projects or activities of the government requiring adequate external technical and professional expertise that are beyond the capacity of the government to undertake, such as but not limited to advisory and review services, pre-investment or feasibility studies, design, construction supervision, management and related services, and other technical services or special studies. Next is GEPS. It refers to the Government Electronic Procurement System as provided in the Section 8 of this Act. Goods. It refers to all items, supplies, materials, and general support services except consulting services and infrastructure projects which may be needed in the transaction of public businesses or in the pursuit of any government undertaking, project, or activity, whether in the nature of equipment, furniture, stationery, materials for construction, or personal property of any kind, including non-personal or contractual services, such as the repair, maintenance of equipment and furniture, as well as trucking, hauling, janitorial, security, and related or analogous services, as well as procurement of materials and supplies provided by the procuring entity for such services. Next is GPPB. It refers to the Government Procurement Policy Board established in accordance with the Article of this Act. Article 10 of this Act. So GPP simply means Government Procurement Policy Board. Okay, in accordance of the Article 10 of this Act. Next is the head of procuring entity. It refers to the head of the agency, governing board, or its duly authorized official, Okay, so it also refers to the local chief executive for local government units, provided that in a department office or agency where the procurement is decentralized, the head of each decentralized unit shall be considered as the head of a procuring entity, subject to the limitations and authority delegated by the head of department, office, or agency. Next is the infrastructure projects. It includes the construction, improvement, rehabilitation, demolition, repair, restoration, or maintenance of roads and bridges, railways, airports, seaports, communication facilities, civil works components of information technology projects, irrigation, flood control and drainage, water supply, sanitation, sewerage, and solid waste management, systems, shore protection, energy power and electrification facilities, national buildings, school buildings, hospital buildings, and other related construction projects of the government. Next is the IRR. It refers to the implementing rules and regulations to be promulgated in accordance with Section 75 of this Act. Next is the portal. Portal refers to the website that aggregates a wide variety of content for the purpose of attracting a large number of users. Next is the procurement. Procurement, it refers to the acquisition of goods, consulting services, and the contracting of the infrastructure projects by the procuring entity. Procurement shall also include the lease of goods and real estate with respect to real property. Its procurement shall be governed by the provisions of Republic. Republic Act Number 8974, entitled An Act to Facilitate the Acquisition of Right-of-Way Site or Location for National Government Infrastructure Projects and for other purposes, and other applicable laws, rules, and regulations. Next is the procuring entity, refers to any branch, department, office, agency, or instrumentality of the government, includes state, universities, and colleges, government-owned and or controlled corporations, government, financial institution, and local government units, procuring goods, consulting services, and infrastructure projects. Okay, for the last but not the least, section 6, entitled Standardization of Procurement Process and Forms. It is to systematize the procurement process, avoid confusion, and ensure transparency. The procurement process, including the forms to be used, shall be standardized insofar as practicable.
Hello everyone, I am Aeron Jay and I will be discussing lesson 2.1. Lesson 2.1, Civil Code of the Philippines. An act ordained and institute the Civil Code of the Philippines, RA 386. Title, Obligations, Chapter 1. General Provisions, Article 1156 to 1162. Chapter 2, Nature and Effects of Obligations, Article 1163 to 1178. Chapter 3, Different Kinds of Obligations. And we have sections up to section 6. Section 1, Pure and Conditional Obligations, Article 1179 to 1192. Section 2, Obligations with the period, Article 1193 to 1198. Section 3, Alternative Obligations, Article 1199 to 1206. Section 4, Joint and Solidary Obligations, Article 1207 to 1222. Section 5, Divisible Obligations, Article 1223 to 1225. Section 6, Obligations with the Penal Clause, Article 1226 to 1230. Chapter 4, Extinguishment of Obligations. Section 1, Payment or Performance, Article 1232 to 1261. Section 2, Loss of the thing due, Article 1262 to 1269. Section 3, Continuation or remission of the debt, Article 1270 to 1274. Section 4, Confusion or Merger of Rights, Article 1275 to 1277. Section 5, Compensation, Article 1278 to 1290. Section 6, Innovation, Article 1291, 130. Chapter 1, General Provisions, Article 1156. An obligation is a juridical necessity to give, to do or not to do. Article 1157. Obligations arise from number 1, law, number 2, contracts, number 3, quasi-contracts, number 4, acts or omissions punishment by law, and number 5, quasi-delegates. Article 1158. Obligations derived from law are not presumed, only those expressly determined in this code or in special law or demandable, and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen by the provisions of this book. Article 1159. Obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. Article 1160. Obligations derived from quasi-contracts shall be subject to the provisions of Chapter 1, Title 17 of this book. Article 1161. Civil obligations arising from criminal offences shall be governed by the penal laws, subject to the provisions of Article 2177 and of the pertinent provisions of Chapter 2, Preliminary Title on Human Relations, and the title of and of Title 18 of this book, regulating damages. Article 1162. Obligations derived from quasi-delegates shall be governed by the provisions of Chapter 2, Title 17 of this book, and be special laws. Chapter 2, Nature and Effects of Obligations. Article 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties required another standard of care. Article 1164. The creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. Article 1165. When what is to be delivered is a determinating, the creditor, and in addition to the right granted him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, he may ask the obligation be complied with at the expense of the debtor. If the obligor delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. Article 1166. The obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not have been mentioned. Article 1167. If a person obliged to do something fails to do it, the same shall be executed at his cost. The same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. Article 1168. When the obligation consists in not doing and the obligor does what has been forbidden him, shall also be undone at his expense. Article 1169. Those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. However, the demand by the creditor shall not be necessary in order that delay may exist. Number 1. When the obligation or the law expressly so declare, or number 2. When from the nature and the circumstances of the obligation, it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contracts, or number 3. When demands would be useless, as when the obligor has rendered it beyond his power to perform. In reciprocal obligations, neither party incurs in delay, the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the parties fulfills his obligation, delay by the other begins. Article 1170. Those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof are liable for damages. Article 1171. Responsibility arising from fraud is demandable in all obligations. Any waiver of an action for the future fraud is void. Article 1172. Responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts according to the circumstances. Article 1173. The fault of negligence of the obligor consists in the omission of the diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, the time, and of the place. When negligence shows bad faith, the provisions of Article 1171 and 2201, Paragraph 2 shall apply. If the law or contracts does not state diligence which is to be observed in the performance, that which is expected of a good father of a family shall be required. Article 1174. Except in cases expressly specified by the law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no persons shall be responsible for those events which could not be foreseen, or which, though foreseen, were inevitable. Article 1175. Serious transactions shall be governed by special laws. Article 1176. The recipient of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid. The receipt of a later installment of a debt without reservation as the prior installment shall likewise raise the presumption that such installments have been paid. Article 1177. That creditor, after having pursued the properly in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them. Article 1178. Subject to the laws, all rights acquired in virtue of an obligation are transmissible, if there has been no stipulation to the contrary. Chapter 3. Different kinds of obligations. Section 1. Pure and conditional obligations. Article 1179. Every obligation whose performance does not depend upon a future or uncertain event, or upon past event unknown to the parties, is demandable at once. Every obligation which contains a resolutory condition shall also be demandable, without prejudice to the effects of the happening of the event. Article 1180. When the debtor binds himself to pay, when his means permit him to do so, the obligation shall be deemed to be one with a period, subject to the provisions of Article 1197. Article 1181. In condition obligations, the acquisitions of rights, as well as the extinguishment or loss of those already acquired, shall depend upon the happening of the event, which constitutes the condition. Article 1182. When the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. If it depends upon chance or upon the will of a third person, the obligation shall take effect in conformity with the provisions of this code. Article 1183. Impossible conditions, those contrary to good customs or public policy, and those prohibited by law, shall annul the obligation which depends upon them. If the obligation is divisible, the part thereof which is not affected by the impossible or unlawful condition shall be valid. The conditions not to do an impossible thing shall be considered as not having been agreed upon. Article 1184. The condition that an event happen at a determinate time shall extinguish the obligation as soon as the time expires, or if it has become indubitable that the event will not take place. Article 1185. The condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed, or if it has become evident that the event cannot occur. If the time has been fixed, the conditions shall be deemed fulfilled at such time as may have probably been contemplated, bearing in mind the nature of the obligation. Article 1186. The condition shall be deemed fulfilled when the obligor voluntarily prevents its fulfillment. Article 1187. The effects upon conditional obligation to give once the condition has been fulfilled shall retroact to the day of the constitution of the obligation. Nevertheless, when the obligation imposes reciprocal prestations upon the parties, the fruits and interest during the pendency of the condition shall be deemed to have been mutually compensated. If the obligation is unilateral, the debtor shall appropriate the fruits and interest received, unless from the nature and circumstances of the obligation it should be inferred that the intentions of the persons constituting the same was different. On obligations to do and not do, the court shall determine in each case the retroactive effect of the condition that has been complied with. Article 1188. The creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his right. The debtor may recover what during the same time he has paid by mistake in case of a suspensive condition. Article 1189. When the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition. 1. If the thing is lost without the fault of the debtor, the obligation shall be extinguished. 2. If the thing is lost through the fault of the debtor, he shall be obliged to pay damages. It is understood that the thing is lost when it perishes or goes out of commence or disappears in such a way that its existence is unknown or it cannot be recovered. 3. When the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. 4. If it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment with indemnity for damages in either case. 5. If the thing is improved by its nature or by time, the improvement shall inure to the benefit of the creditor. 6. If it is improved at the expense of the debtor, he shall have no other right than that granted to the usufructuary. Article 1190. When the conditions have further purpose the extinguishment of an obligation to give the parties upon the fulfillment of said conditions shall return to each other what they have received. In case of the loss, deterioration, of improvement of the thing, the provisions which, with respect to the debtor, are laid down in the preceding article shall be applied to the party who is bound to return. As for the obligations to do and not to do, the provisions of the second paragraph of Article 1187 shall be observed as regards the effect of the extinguishment of the obligation. Article 1191. The power to rescind obligation is applied in reciprocal ones in case one of the obligor shall not comply with what is incumbent upon him. The injured party may choose between the fulfillment and the rescission of the obligation. With the payment of damages in their case, he may also seek rescission even after he has been chosen fulfillment, if the latter should become impossible. The court shall declare the rescission's claim unless there be just cause authorizing the fixing of a period. This is understood to be without prejudice to the rights of third person who have acquired the thing, in accordance with Article 1385 and 1388 in the mortgage law. Article 1192. In case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined till the parties first violated the contracts, the same shall be deemed extinguished and each shall bear his own damages. Chapter 3. Different kinds of obligations. Section 2. Obligations with a period. Article 1193. Obligations for whose fulfillment a day certain has been fixed shall be demandable only when that day comes. obligations with a resolutory period take effect at once, but terminate upon arrival of the day certain. A day certain is understood to be that which must necessarily come, although it may not be known when. If the uncertainty consists in whether the day will come or not, the obligation is conditional, and it shall be regulated by the rules of the preceding section. Article 1194. In case of loss, deterioration, or improvement of the thing before the arrival of the day certain, the rules in Article 1189 shall be observed. Article 1195. Anything paid or delivered before the arrival of the period, the obligor being unaware of the period, or believing that the obligation has become due and demandable, may be recovered with the fruits and interest. Article 1196. Whenever in an obligation a period is designated, it is presumed to have been established for the benefit of both the creditor and the debtor, unless from the tenor of the same or the circumstances it should appear that the period has been established in favor of one of the other. Article 1197. If the obligation does not fix a period, but from its nature and the circumstances, it can be inferred that a period was intended. The courts may fix the duration thereof. The courts shall also fix the duration of the period when it depends upon the will of the debtor. In every case, the court shall determine such period as may, under the circumstances, have been probably contemplated by the parties. Once fixed by the courts, the period cannot be changed by them. Article 1198. The debtor shall lose every right to make use of the period. 1. When after the obligation has been contracted, he becomes insolvent unless he gives a guarantee or security for the debt. 2. When he does not furnish to the creditor the guarantees or securities which he has promised. 3. When by his own act he has impaired said guarantees or securities at their establishment, and when through a fortuitous event they disappear, unless he immediately gives new ones equally satisfactory. 4. When the debtor violates an undertaking, in consideration of which the creditor agreed to the period. 5. When the debtor attempts to abscond.
Good morning. My name is Blanka Borja. I'm the reporter for Lesson 3, which is all about CIAP Document 102, Uniform General Conditions of Contract for Private Construction. CIAP is the Construction Industry Authority of the Philippines, is an attached agency of the Department of Trade and Industry, or the DTI, which was created under Presidential Decree number 1746 as amended by Executive Order numbers 679 and 768 to promote, accelerate, and regulate the growth and development of the construction industry. Under the said law, the CIAP is mandated, among others, to recommend and encourage the adoption of equitable and realistic contract conditions for construction. In the line with such mandate, the CIAP established the Uniform General Conditions of Contract for Private Construction, or the CIAP Document 102. It was formulated by the community composed of representatives from various professional organizations, namely the Council of Engineering Consultants of the Philippines, Construction Project Management Association of the Philippines, Chamber of Real Estate and Builders Association, International Federation of Building and Woodworkers, Philippine Constructors Association Incorporated, Philippine Chamber of Commerce Incorporated, Philippine Institute of Construction Arbitrators, now it is called the Philippine Institute of Construction Arbitrators and Mediators. Next, we have Philippine Institute of Civil Engineers, Subdivision and Housing Developers Association of the Philippines, United Architects of the Philippines, Society of Philippine Accredited Consultant, and the Confederation of Filipino Consulting Organizations Incorporated. The Philippine Domestic Construction Board, or the PDCB, and the Philippine Overseas Construction Board, or the POCB, two of the implementing arms of the CIAP, have likewise submitted their inputs in the formulation of CIAP Documented 102 to support their recommendation for CIAP to bolster the acceptance, and use of the said document in private construction. The first edition of CIAP Document 102 was published on the 5th of October in 1997. The revised version was issued on the 90th June of 2004 to incorporate prevailing best practices and the changes that evolved in the construction industry over the years. In 2017, DTI Undersecretary Attorney Ruth B. Castillo, in accord with PDCB's recommendation for CIAP to boost its efforts in promoting the use of CIAP Document 102 and enhance its marketability, especially to small contractors, approved the formulation and publication of the primer to increase the public's awareness about the existence and importance of CIAP Document 102 in promoting fair contractual relationships in the construction industry. Through this primer, the PDCB hopes to inform the public and all sectors concerning of the existence of CIAP Document 102, whose provisions reflect usages and customs in the Philippine construction industry as reference and guide in the interpretation of contract provisions and fill the omission of stipulation which are ordinarily established. What is CIAP Document 102 and its intent? CIAP Document 102, or the Uniform General Conditions of Contract for Private Construction, contains terms and conditions ordinarily established in construction contracts. It is intended for use in contracts for private construction in the Philippines. CIAP Document 102 was formulated to provide the procedures, guidelines, and criteria to be used by parties in the construction contract or reference to the contract to address deficiencies and or any ambiguity. The CIAP Document 102 contribute to the enhance of the fair contractual relationships in the construction industry. What is a construction contract? A typical construction contract consists of an agreement, general conditions, drawing, specification, and other documents. Contract is used to describe the combination of two sets of documents, the agreement and the contract document. Agreement is used to describe the agreement signed by the owner and the contractor, including the contract document. Contract documents are attached to the agreement identified therein as contract documents, including all additions, deletions, and modifications, which generally include the following special provisions or the condition: general conditions, specifications, drawing, and the other bid document. Special provision or conditions are instructions which are issued prior to bidding to supplement and or modify the drawings, the specification, and or general conditions of the contract. The specifications are written or printed description of the work to be done, describing qualities or the material to be used, the equipment to be installed, and the mode of construction. Drawings are graphically presentations of work including supplementary details and shop drawings. General conditions of contract pertain to the roles, rights, and obligations of the contracting parties, and the rules and procedures by which the parties and everyone concerned will be able to meet their obligations and perform the works covered under the contract. Under CIAP Document 102, we have 11 sections, which are Section 1, Definition and Documents, Section 2, Laws, Regulations, Site Conditions, Permit and Taxes, Section 3, Equipment and Materials, Section 4, Premises and Temporary Structure, Section 5, Protection of Work and Property, Section 6, Labor, Work and Payments, Section 7, Contractor Separate, Contractor-Subcontractors Relationship, and Section 8, Suspension of Work and Termination of Contract, Section 9, Responsibilities and Liabilities of Contractor and the Owners. Section 10 is the Owner's Representative, and Section 11, Schedule of the Time Limits. What is the importance of clear contract terms and harmonized contract documents? Many disputes in construction arise from inconsistent and ambiguous contract terms and conditions, which lead to varied interpretation and conflict between the contracting parties. To avoid disputes that may affect the completion of the work and strain the relationship of the parties, it is important that contract documents objectively reflect the agreement and true intent of the parties. Section 1. Definition and documents provide the definition of terms used, the execution, correlation, and intent contract document, as well as the rules to be followed in case of conflict and discrepancy. What are the obligations of the contracting parties when it comes to permits and licenses and payment? According to Section 2, laws, regulations, site condition, permits, and taxes, stipulates compliance with all laws in so far as they are binded upon or affect the parties to the contract. The owner, with the contractor's assistance, shall secure and pay all construction permits and licenses necessary for the execution of the work. The contractor shall secure the final occupancy permit, but he shall not be responsible to the owner if, without his fault, the license is not issued or there was delayed in its issuance. The contractor shall pay all taxes as required by laws pertinent to the construction of the project. Who is in charge of the safety and sanitation in the work premises? Pursuant to Section 4 and 6, the contractor is in charge of the safety and sanitation at the work site during and upon completion of work. Who is responsible for accidents in the work premises? According to Section 9, Article 30, contractor's responsibility for accidents and damages is stated that the contractor shall be primarily responsible for all safety measures in executing the work. What are the bonds and guarantees required of the contractor? According to Section 9, Article 31, contractor's insurance and bonds enumerates the insurance, bonds, and guarantees required of the contractor, to wit, contractor's liability insurance, accident insurance of the workers, contractor's fire insurance, contractor performance and payment bonds, contractor's guarantee bond, and contractor's guarantee warranty. Next, is the owner required to obtain insurance? According to Article 32.02, it states that the owner may opt to obtain an insurance that will protect him from his contingent liability. Is the subcontractor also required to obtain bonds and insurance? According to Article 33.03, provides that the subcontract must require the subcontractor to obtain the same bonds and insurance covered as are required of the contractors. Is it required to appoint an owner's representative? According to Section 10, Article 34, owner's representative provides for the appointment of the representative of the owner and the extent and limitation of the authority granted to the representative. Is the owner required to make advance payment to the contractor? According to Article 32, owner's responsibilities and liabilities provide that the owner shall pay the contractor an advance payment, which shall be used for mobilization, purchase of materials, and shall be recouped pro rata in the progress billing. Can the contractors commence with the work even without the consent of the owner? According to Article 21.01, notice to proceed when required states that premature commencement of construction shall be at the contractor's risk and the owner gives the contractor's express or implied authority to do so. How can the owner ensure the quality and efficient execution of the work? In Section 6, Labor, Work, and Payments provides that the owner shall at all times have access to the work and shall provide sufficient number of inspectors while work is in progress to ensure quality. Is submission of materials and equipment allowed? According to Section 3, Equipment and Materials provides that all materials and equipment must conform to all laws that are in force and applicable during the period of construction, and the contractors shall bear with all damages by reason of any delay in the work arising from failure to comply with such laws. What constitutes change order and adjustment of contract price? According to Section 6, Article 20, describes the circumstances that are covered by a change order and the warrant adjustment in contract price, if necessary, corresponding adjustment in completion time. What is progress payment? The contractor may submit periodically but not more than once each month a request for payment for work done. Each request for progress payment shall be computed from the work completed on all items listed in the breakdown of work and corresponding value, less a retention of 10% of the progress payment to the contractor. What is retention money? Progress payments are subject to retention of 10%. The purpose of retention is to cover uncorrected discovered defects and third parties' liabilities. What are the documents to be submitted by the contractor to the owner before final payment? First, the certificate of final building occupancy. Next, the certificate of final inspection of electrical, telephone, sanitary, mechanical, water, gas, safety, and other utilities. Next is the original and the 3 sets of print of as-built drawings of electrical, sanitary, gas, telephone, and mechanical works. Also, 3 copies of directory of panel boards and list of circuits. 3 copies of instructions and manual for operating and maintaining of fixtures and equipment. Also, 3 copies of keying schedule and release of the lines arising under the contract. Does the release of final payment relieve the contractor of liability for any defect in the work? After release of the final payment and the acceptance of the owner of the work, the contractor is still liable for any defect in the work. If the defect is hidden, the owner's acceptance of the work was made with reservation the specific portion of the work. Also, inferior work or work which does not comply with the drawings and specification and is apparent upon inspection by the owner within 1 year from final payment, and hidden defect discovered within the warranty period or within 1 year from posting of guarantee bond. The contractor is likewise liable for damages if the edifice falls within 15 years from completion of the structure on account of defects in the construction or the use of materials of the inferior quality or due to any violation of the terms of the contract as provided in Article 1723 of the Civil Code of the Philippines. What is mediation? Mediation, as defined under Section 6 of the CIAC Mediation Rules, shall mean a voluntary process in which a mediator selected by the disputing parties facilitates communication and negotiation and assists the parties in reaching a voluntary agreement regarding a dispute. What is arbitration? It is defined as the investigation and determination of matters of differences between contending parties by one or more unofficial persons called arbitrators or referees chosen by the parties. Is intended to avoid the formalities, the delay, the expense, and vexation of the ordinary litigation. What are the issues that can be submitted for mediation or arbitration? The jurisdiction of the CIAC may include, but it is not limited to, the following: violation of specifications for materials and workmanship, violation of the terms of agreement, interpretation and or application of contractual provisions, commencement time and delays, maintenance and defects, changes in contract cost, payment default of employer or contractor, and amount of damages and penalties.
Lesson 4. Lesson 4 is Presidential Decree number 1594. prescribing policies, guidelines, rules and regulations for government infrastructure contracts. Section 1. Policy objectives. It is the policy of the government to adopt a set rules and regulations covering government contracts for infrastructure and other construction projects which shall bring about maximum efficiency in project implementation and minimize the project costs and contract variations through sound practices in contract management, promote a healthy partnership between the government and the private sector in furthering national development, and enhance the growth of the local construction industry, and optimize the use of indigenous manpower, materials, and other sources. Section 2. Detailed engineering. No bidding and award of contract for a construction project shall be made unless the detailed engineering investigations, surveys, and design for the project have been sufficiently carried out in accordance with the standard and specification to be established under the rules and regulations to be promulgated pursuant to Section 12 of this decree, so as to minimize quantity and cost overruns and underruns, change orders and extra work orders, and unless the detailed engineering documents have been approved by the Minister of the Public Works, Transportation and Communications, and the Minister of Public Highways of the Minister of Energy, as case may be. Section 3. Pre-qualification of prospective contractors. A prospective contractor may pre-qualify to offer his bid or tender for a construction project only if he meets the following requirements. First, legal requirements. The prospective contractor must have been licensed as a contractor for the current year pursuant to the Republic Act No. 4566, must have paid his privilege tax to practice or engage in the contracting business for the current year, must comply with Administrative Order No. 66 of the Office of the President of the Philippines, and must comply with other existing pertinent laws, rules, and regulations. Second, technical requirements. The prospective contractor must meet the following technical requirements to be established in accordance with the rules and regulations to be promulgated pursuant to Section 12 of this decree to enable him to satisfactorily prosecute the subject project. Third, financial requirements. The net worth and liquid assets of the prospective contractor must meet the following requirements to be established in accordance with rules and regulations to be promulgated pursuant to Section 12 of this decree to enable him to satisfactorily execute the subject project. The prospective contractor may be allowed to cover the deficiency in the required net worth through a line of credit fully committed to a subject project by a bank or financial institution acceptable to the ministry concerned. Lastly, Filipino participation. The government shall promote maximum participation of eligible Filipino contractors in all construction projects. Bidding. Construction projects shall generally be undertaken by contract after competitive public bidding. Project may be undertaken by administration or force account or by negotiated contract only in exceptional cases where the time is of the essence, or where there is lack of qualified bidders or contractors, or where there is a conclusive evidence that greater economy and efficiency will be achieved through this arrangement, and in accordance with the provision of laws and acts on the matter, subject to the approval of the Ministry of Public Works, Transportation and Communications, the Minister of Public Highways, or the Minister of Energy, as the case may be. If the project cost is less than 1 million pesos, and the President of the Philippines, upon the recommendation of the Minister, if the project cost is 1 million pesos or more. A bidder's bond in an amount to be established in accordance with the rules and regulations to be promulgated pursuant to Section 12 of this decree shall accompany the bid or guarantee that a successful bidder shall, within a prescribed period from receipt of the notice of award, enter into account and furnish the required performance bond for the faithful and complete prosecution of the work specified in the contract documents. Section 5. Award and contract. The contract may be awarded to the lowest pre-qualified bidder whose bid as evaluated complies with all the terms and conditions in the call for the bid and is the most advantageous to the government. To guarantee the faithful performance of the contractor, we shall, prior to the award, post a performance bond in an amount to be established in accordance with the rules and regulations to be promulgated under Section 12 of this decree. All awards and contracts duly executed in accordance with the provisions of this decree shall be subjected to the approval of the Minister of Public Works, Transportation and Communications, and the Minister of the Public Highways or Minister of Energy, as the case may be. Section 6. Assignment and Subcontract. A contractor shall not assign, transfer, pledge, subcontract, or make any other disposition of the contract or any part of interest therein except with the approval of the Minister of Public Works, Transportation and Communications, and the Minister of Public Highways, or the Minister of Energy, as the case may be. Approval of the subcontract shall not relieve the main contractor from any liability or obligation under his contract with the government, nor shall it create any contractual relation between the subcontractor and the government. Responsibility of the contractor. The contractor shall assume full responsibility for the contract work until its final acceptance by the government and shall be held responsible for any damage or destruction of works except those occasioned by force majeure, except likewise for the force majeure. The contractor shall be fully responsible for the safety, protection, security, and convenience of his personnel, third parties, and the public at large, as well as the works, equipment, installation, and the like to be affected by his construction work. Section 8. Adjustment and Contract Price. Adjustment of contract price for construction project may be authorized by the Minister of Public Works, Transportation and Communications, and the Minister of Public Highways or the Minister of Energy, as the case may be, upon recommendation of the National Economic and Development Authority. If during the effectivity of the contract, the cost of labor, equipment, materials, and supplies required for the construction should increase or decrease due to direct act of the government, the adjustment of the contract price shall be made using appropriate formulas established in accordance with the rules and regulations to be promulgated under Section 12 of this decree. Section 9. Change order and extra work order. A change order or extra work order may be issued only for works necessary for completion of the project and, therefore, shall be within the general scope of the contract as bidded and awarded. All change orders and extra work orders shall be subject to the approval of the Minister of Public Works, Transportation and Communications, the Minister of Public Highways, or the Minister of Energy, as case may be. Section 10. Inspection and Construction of Contract Work. Inspection of the contract work shall be made by the government while such contract work is in progress to ascertain that the completed works comply in all respect with the standards and requirements set forth in the contract documents. Notwithstanding such inspection, the contractor shall be held responsible for the acceptability of the finished works. The contractor shall promptly replace all materials and correct all works determined by the government as failing to meet contract requirements. Section 11. Government's right to take over contract work. A government may take over the contract work should contractor abandon the contract work, or unduly delay the prosecution of the contract work, or become insolvent, or assign his assets for the benefits of his creditors, or be judged bankrupt, or assign the contract work without written approval by the government, or violate any condition or term of contract. In any of these cases, the government may terminate the employment of the contractor and take over the contract work after giving due notice to the contractor and his sureties. Section 12. Implementing Rules and Regulations. The Minister of Public Works, Transportation and Communications, as the lead official, the Minister of Public Highways, the Minister of Energy, and the Director General of the National Economic and Development Authority shall jointly promulgate the rules and regulations to implement the provision of this decree. Once approved by the President of the Philippines, these implementing rules and regulations shall be applicable to all contracts for infrastructure and other construction projects of all government agencies, including government-owned or controlled corporations and other instrumentalities. Section 13. Separability Clause. If any provisions of this decree is held unconstitutional, the other provisions shall remain valid. Section 14. Repealing Clause. All acts, charters, decrees, letters of instructions, executive orders, proclamations, rules and regulations, or parts thereof in conflict with the provisions of this decree are hereby repealed or modified accordingly. Section 15. Effectivity. This decree shall take effect immediately, done in the city of Manila this 11th day of June, in the year of our Lord, 1978.